You're now listening to Durian ASEAN, the voice of discovery and sharing.
The Durian Heat, bringing big ideas and critical opinions in Southeast Asia.
Hey, this is Arlene and you're listening to Durian ASEAN, the voice of discovery and sharing. Today with me is Khoo, a lawyer from the Bar Council, and he will be sharing with us on the National Security Council bill, a bill that has just been passed in the Malaysia's lower house. And we will be talking about whether it is for security or is it for liberty in a way. I want to ask you, I think the most obvious question, do you agree with the passing of NSC bill? It will make us more secure and more free as citizens?
Well, both from a professional point of view and representing the Bar Council of Malaysia, and as well as a personal view, I don't really see the need for this piece of legislation. To me, it's a bad piece of legislation. It has significant weaknesses, and it, I think, poses a huge problem for civil liberties in Malaysia. So for those reasons, I'm strongly opposed to the bill.
Before we go through the contents of the bill, I mean, we all know that terrorism has become like the global go-to word when it comes to security threats, especially terrorism related to ISIS. Malaysia, including some of our neighboring countries, have been one of the key exporters for global terrorists. Do you think that laws like the National Security Council bill would actually protect Malaysians?
I think if you put aside the National Security Council bill for a moment, in Malaysia we already have a whole range of laws. I'm not saying that they're necessarily good laws, but we still have those laws which to me are more than sufficient to cater and to deal with any threat or potential threat of terrorism arising, whether within Malaysia or from outside Malaysia. In the last few months especially, we've seen the passage or the bringing into force of very draconian laws which would allow the government to detain people without trial for extended periods of time, for stopping people from leaving the country, whether or not you are a citizen or a non-citizen. And so there are already ample, the government already has a whole arsenal of different types of legislation that it can use.
If you can share with us some of the existing laws that the government has used to counter or to contain terrorists.
Well, again, the problem with the legislation that the government has used is that it lacks transparency. So, for example, we've only had comments and some passing references to the Prevention of Crime Act, which actually is an old piece of legislation from 1959, but which the government has updated and expanded. And that is generally being used, according to the government, to counter domestic terrorism.
Has it been successful to, counter terrorism?
Well, the point is we don't know. And I suppose the government will try to say the fact that you can't see anything happening means that it has been successful because we've managed to stop potential terrorists from carrying out their threatened activities. The point is that we don't know. There's very little information about the numbers of people who are being detained. And certainly there hasn't been a legal challenge to the detention. I think there are questions about the ability of people who are detained under the Prevention of Crime Act to have access to legal representation. So the fact of the matter simply is that we don't know because we've not had access to people who have been detained either under the Prevention of Crime Act or the new piece of legislation which has been recently brought into force, which is the Prevention of Terrorism Act, which has similar provisions like the Prevention of Crime Act, basically that you can be detained without trial for up to 2 years at a time, and that period of detention can be renewed indefinitely. And I need to stress it's detention without trial. So there's no legal process. There's no courts involved. It's administratively ordered detention.
As part of the Bar Council, do you have access to statistics in terms of how many people have been charged under the terrorist laws, whatever terrorist laws that we have currently?
The Bar Council is in no special position when it comes to information. We still have to ask questions like anyone else, and we're still denied answers to Parliament. So it's only by way really of parliamentary questions where we actually get some kind of answers from the government.
So far, I mean, you don't have any information regarding like how many people have been charged under such law that pose national security threats to Malaysia. So not even a single person.
No, that's not quite correct. I mean, you've had statements. For example, there was a statement which was reported in the press in October this year. The Prevention of Terrorism Act was brought into force on the 1st of September of this year, and I think there was a parliamentary question and a parliamentary reply in October, giving a particular number of people who apparently had been detained or rather arrested under the Prevention of Terrorism Act. And then there was a breakdown of the number of people that had been deported. So obviously there were some foreigners, people who were deported, people who were ultimately charged with some form of offense or another, not relating directly to terrorism. And then according to that statement, there were something like 20 plus people who actually had been given detention orders. So that's the first and only information that we've seen being given to Parliament on the use of the Prevention of Terrorism Act.
Why do you, as a lawyer and as a part of Bar Council, disagree with the law or the spirit of law to prevent terrorist activities?
Well, I think the simple answer is there are already enough laws. This is a overkill piece of legislation, and we question the motives of the government in introducing this piece of legislation because it has attempted to sidestep the existing mechanisms for dealing with terrorism.
To add further, I mean, one of the justification by people who support the law is because it reduces bureaucracy. It centralizes the power so that the government can make direct and also precise decision when it comes to trying to counter certain terrorist activities in this country. Is that what you would agree?
I would disagree simply because there has been no indication that the existing legislation or the existing mechanism to deal with threats of terrorism are inadequate.
But what about in terms of the bureaucracy or the bureaucratic process?
What bureaucracy has there been? In 1969, when we had a declaration of emergency, I've reviewed some of the emergency orders that have been issued, and they were issued within 1 to 2 days of the proclamation of the emergency. So if in 1969 you could already do these things in a matter of 1 or 2 days, I would have thought that in 2015 you could do them much faster. So I don't see any reason to expect there to be bureaucratic hurdles or delays that would prevent a speedy response to any threat of terrorism that the country faces.
Okay. We'll take a short break. When we return, we'll discuss further on the NSC bill, whether it's going to really curtail our civil liberties.
The Durian Heat, bringing big ideas and critical opinions in Southeast Asia.
This is Arlene. You're back with me on our Durian ASEAN, where we bring you interesting discussion from around Southeast Asia. This time we focus on the National Security Council bill, which has recently been passed by the lower house of the Malaysia's parliament. So, moving on to discuss further on the NSC bill. which part of the NSC bill that really concerns you the most?
I think the honest answer is that it's the whole bill.
The whole bill.
I'm sorry to have to say that, but it's the whole necessity of the bill which is questionable. I mean, for the advantage of your listeners who perhaps may not understand the constitutional structure in Malaysia, in our constitution, Article 150 already posits the possibility of a serious threat to national security, which would require the proclamation of an emergency. And under the provisions of Article 150, it is His Majesty the King, whom we call in Malaysia the Yang di-Pertuan Agong, who makes the proclamation of emergency. And what happened in 1969, as an example, when a state of emergency was proclaimed after some race riots broke out in Malaysia, the Yang di-Pertuan Agong proclaimed a state of emergency and then inaugurated a National Operations Council, an NOC, which then assumed executive power to run the country. Parliament was suspended, and the director of the National Operations Council, then the then Deputy Prime Minister, took charge of running the country. So it was done with the consent and with the basically the initiation of the King. What we have in the National Security Council bill is an attempt to set up an alternative mechanism where you do not need a proclamation by the Yang di-Pertuan Agong. And serious questions are therefore raised as to why the government feels it necessary to create a mechanism that avoids having to go to the King for the proclamation. So, people talk about the present, perhaps, decline in the relationship between the executive and the institution of the monarchy. And again, for your listeners, Malaysia has a very interesting concept where we have a rotating monarchy. So we have 9 royal households in Malaysia, and each of them take turns 5 years at a time to assume the office of the Yang di-Pertuan Agong. And so looking down the road at future houses which may become the Yang di-Pertuan Agong in the future, we do see the possibility of a Yang di-Pertuan Agong down the road not agreeing to a request by the government to declare a state of emergency.
So it has happened in the past?
Well, no, it hasn't. I mean, we've only had 4 proclamations of emergency, and in all those 4 occasions, there was never any sense that the Yang di-Pertuan Agong refused to proclaim a state of emergency. So the question is, why does the government feel the need to avoid that? And if you argue that it's done for administrative efficiency, then I go back to what I said just before we had the break. In 1969, the emergency situation broke out on the 13th of May. By the 15th of May, all the proclamations had been done. All the orders to create the National Operations Council had already been done. So it's a matter of 1 to 2 days. So I don't think in 2015 we are going to see, a less speedy proclamation of emergency if it came to that. So I don't buy the argument from the government that this is being done for to expedite a response to the situation or to avoid any potential delay. To me, what is clear is that the government seems to be worried that a sitting Yang di-Pertuan Agong may not want to accede to a request by the government of the day to declare a proclamation of emergency. And that can happen for many reasons. Maybe the Yang di-Pertuan Agong of the day does not believe that there is a genuine state of emergency, that it may be something that's been concocted by the government of the day to attempt to stay in power and to avoid elections and to avoid being accountable to the citizens. And if that's the case, then that would not be a proper reason to declare a state of emergency.
Looking at the current situation right now within the monarchy, has the monarchy sort of present itself to distant from majority of the government's decision on different political issues?
There is really only one issue at the moment that stands out, and which is the allegations of financial mismanagement or even possible corruption that is being thrown at the current Prime Minister in terms of monies that have been deposited in his personal bank accounts. And unprecedented, the Conference of Rulers, which is the coming together of all the 9 royal families, issued a statement of sorts some time ago, calling for the speedy conclusion to the investigations in relation to this, what is known as the 1MDB issue. And to many of us, this was, I think, the first time where the Conference of Rulers had come up with
such a statement.
And it seemed to suggest that the Conference of Rulers were quite worried about the allegations of financial impropriety which had been leveled against the government, and in particular the Prime Minister. And so it's not hard to imagine that there may be some concerns about whether or not a security threat faced by the country is in actual fact a security threat against the country, or whether it is merely a threat against the political survival of a group of people who currently form the government of the country.
Besides the monarchy, which we have seen, as you explained so far, trying to distance itself, trying to provide its own moral statement on what the government's conduct has been on some of the political issues that have been crop up recently. What about other institutions in Malaysia? Has it been a threat to the government as well?
Well, what we've also seen in very recent times is a flexing of independence by certain other institutions of government. So, for example, the central bank was adamant that there were commissions of transgressions of, say, exchange control regulations in relation to the 1MDB issue. And so while on the one hand the Attorney General had decided that there was nothing substantial enough to proceed with criminal charges, the Governor of the Central Bank decided that there were administrative transgressions of exchange control laws, for example, that she would proceed with in terms of the powers that were within the sole control of the central bank. So it's not. It was very interesting to see this very strong independent stance being taken by the central bank in the face of what the government was trying to say that was not an issue, was no crime had been committed. And it's interesting that in the provisions of the National Security Council bill, a threat to national security can include an economic threat. And so
it's not really about terrorism, if that's what you meant.
Well, yes, it's not simply about terrorism. It's also about threats to national security that may come from social political issues, even economic financial issues. And this is where it's very interesting, because we had a recent incident where 2 persons were arrested under our security offences legislation, and then charged in court for a conspiracy attempting to undermine the banking and financial system of Malaysia. So it's an economic related terror threat, as it were. But what exactly did these two people do? Well, one of them, a chap called Datuk Khairuddin, was basically charged with attempting to undermine the banking financial system. And what he did was to have gone to 5 law enforcement agencies outside the country. So he went to Switzerland, he went to France, he went to the UK, he went to Hong Kong, and he went to Singapore. And he made reports about potential corruption within the government in relation to 1MDB. And he basically asked these 5 law enforcement agencies to start investigating Malaysia, presumably because there was some connection with these 5 countries. And the second person, Matthias Chang, was his lawyer. And this is even more objectionable because Matthias was merely acting, from what we understand, as a legal advisor advising his client. And for that, he was also charged with abetting Datuk Khairuddin. Ultimately, the courts decided that there was an improper charge being leveled against the two, and refused to allow these two individuals to be charged for an offence of threatening the banking and financial system. So here was a situation where the central bank and the courts were telling the government that we don't believe your story. Mm-hmm. We don't believe that these people were involved in what you say they were involved. And so we are going to exercise our independence, and we are going to deny charges being brought against them, or in the other case with the central bank, we are going to proceed with our own investigations and our own administrative powers, even though you don't believe that there is a criminal case against 1MDB in this matter. So you've got the monarchy, you've got the courts, and you've got the central bank in their own way standing up for their independence and refusing to bow to the dictates of the government. So how can the government avoid these kinds of problems? Well, declare not a state of emergency, because that again would go to the need to go to the king, but declare this new thing called a security threat, and to then allow the Prime Minister, in effect, to take over and to become the sole power to be able to run a security area which would have been created as a result of a response to this alleged security threat. To me, it's an attempt to take away, to create, as I said, an alternative mechanism to avoid the checks and balances. So
it's a form of destruction in a way.
Well, it's an attempt to disguise a naked hold on power, a naked grab to stay on in power under the guise of a threat of terrorism and a threat to national security. To me, this is the ulterior motive behind this piece of legislation, which is why it needs to be stopped. And I think there has been insufficient public discussion to understand the rationale of this piece of legislation, and to actually demand for evidence, credible evidence, substantiated evidence that this kind of power is necessary in this day and age for a government in Malaysia, taking into account that they have all these other laws that they can already use in order to address any potential threat of terrorism.
We'll take a short break. When we return, we will discuss further on the NSC bill.
The Durian Heat, bringing big ideas and critical opinions in Southeast Asia.
Hey, this is Arlene. You're back with me again on our Durian ASEAN with Andrew Khoo, a lawyer from the Bar Council. So on our topic today, the NSC bill, security over liberties, with a question mark here. And we want to know further about the fate of the bill right now, because we all know that the bill has been passed on the lower house and now it will be debated on the upper house with senators in it, where the Bar Council is trying to influence their decision making. What is the aim of Bar Council eventually?
Well, the Bar Council merely wants to explain and to articulate the concerns from a rule of law and human rights perspective about the potential dangers of this piece of legislation. So I think Malaysian citizens or people who live in Malaysia should realize that this law, if passed, will, if a security area is created, will allow for basically a sweeping aside of fundamental liberties. So there will be able to be search, detentions, arrests without warrant. There will be the possibility that anyone who is killed as a result of an operation
within the security area,
there will be no accountability, because the law will allow a magistrate to waive the need for a death inquiry or an inquest. So we will never know the reasons why a person has been killed within a security area. So these are some of the checks and balances which currently exist, which will be swept aside in a situation where a security area has been created.
Is there any debate happen during the debate in the lower house on why they put such provision that you mentioned just now?
Well, there was a debate in the lower house of parliament for about 10 hours. Basically, the bill was rushed through the lower house. It was announced on one day, and then by 2 days later, they were having a debate on it, and it was a straight debate for 10 hours, after which it was passed, not even by an actual physical vote, but it was ultimately passed by what is known as a voice vote. So basically, the speaker stands up and asks people whether they support, and they will just shout yay versus nay, and then...
Are you sure this is not like a high school event?
Well, sometimes you think that it's like a cheering session. I know how many cheerers do you have on one side versus the other, and you see who cheers the loudest. That's essentially what a voice vote is. So
is it even a law? I mean, is it even allowed?
It's a parliamentary procedure. You can you can actually pass laws by a voice vote. It's a very convenient way to avoid personal accountability, because then you actually don't have a recorded vote, and so you don't know how your MP would have voted on it. So
I really didn't know about this. This is very interesting.
Yeah. Of course, there was an earlier vote taken on the policy stage, and that's where I think, if memory serves me correctly, 107 government MPs actually voted to approve the bill at the policy level. But ultimately, after the detailed debate, which went on into very early hours of the morning, the bill was passed, but as I said, only by a voice vote. So you have the concerns about basically the sweeping aside of constitutional protections of due process. You can, as I said, be arrested, detained. You or your property can be searched without a warrant, and there is immunity from prosecution for the security forces in their actions. And it's not just your standard immunity. There is an additional immunity in the sense that if in good faith a member of the security force does something or fails to do something which causes injury or death, there is immunity from any potential lawsuit or civil action to hold that person into account. So the danger is that this kind of immunity creates an environment of impunity, where there is no check and balance against any action by the security forces. So the security forces can merely say that they were acting in good faith, and they are allowed to use what is deemed to be reasonable force in order to achieve their security objectives. So reasonable force is not defined. It's commensurate with the perceived threat. So from a human rights point of view, my concern is that it actually will allow for torture.
I see.
Because if there is allegation of an imminent threat, then the police, the army, or whoever constitutes the security forces at that point in time in that operation will be allowed to use reasonable force, proportionate force, in order to obtain information.
If it goes to an unfortunate path of being passed into a law, how would it impact Malaysia?
Well, again, the point is that the security threat is not defined. It can cover many different areas. So it's possible for the government just out of the blue to declare that, we are now facing a security threat, and if it's in a physical area, to create a security area whereby all these civil liberties will in effect...
When you say security area, it's not just small pockets of area, but it can be as big as the state or the country. Is that what you mean?
I mean, it's drafted in the sense that it can be little pockets, or it can be a collection of different pockets, or it can be a bigger area. It can also, yes,
be the whole of Malaysia.
The whole of Malaysia. It can be a whole state within Malaysia. And this is again one of the concerns that we have, in the sense that it could be used to effectively take over control of, say, a state which is currently being governed by parties within the federal opposition.
It reminds me as if we might be going through a martial law.
Well, this is in fact martial law. I mean, it will allow for the deployment of the armed forces in a civilian domestic situation. So if that will actually, I think, qualify as martial law. So the army can come in together with the police and auxiliary police and things like that. And even there's a provision for the use of even external visiting armed forces. So it doesn't just have to be Malaysian. It can be foreign armed forces can also come within the definition of what constitutes a security force.
So Malaysian government can actually borrow armed forces from other countries just to increase whatever security.
The possibility is that, because we have this definition of security forces, and it includes visiting forces as well. But the other thing that I think your listeners should be aware of is that once a security area is declared, and you're talking about whole states, if, for example, a security area is declared over a state, then all the state entities will then be forced to report to the Director of Operations. So no longer reporting to the state government, but to the Director of Operations for that security area. So you have effectively stepped in and taken over effective control of state bodies.
But it's only a small period of time. If I'm not mistaken, a couple of months only, right?
Well, this is the thing. An initial declaration is for up to a period of 6 months. But that period can be extended for periods of 6 months, but can be extended indefinitely. So you can go on and on and on, 6 months extending for further 6 months, and it can go on indefinitely, and until and unless Parliament decides to end that declaration of a security threat. The Prime Minister, on his own accord, can indefinitely extend this period of a security threat. And we've seen government control over Parliament, in the sense that the majority party dominates Parliament, so it wouldn't be difficult for the lower house and the upper house to not pass any resolution to end this period of national threat.
So finally, what can we do about it? I think a lot of people probably they are on their seats wondering, this is something that is on a policy level, but on a community level, what can people do about it?
Well, I think there is still opportunity to persuade the government to withdraw the bill. There is a possibility of trying to lobby the senators, because it's been passed in the lower house, so it's going to go before the Senate, the upper house, next week. And you have, as I understand it, currently 61 senators out of 70. There's some vacancies, so you've got 61 senators. You can lobby those senators, whether they are representatives of your state or whether those are the ones that are being directly appointed by the king. You can lobby them to explain to them your concerns and to ask them to rise above partisan politics and to look at what is in the best interests of the nation as a whole. And the question really has to be asked, is this bill in the best interests of the country? And my answer is that it isn't, because it allows too much power to be concentrated in the hands really of one man. And the danger that power corrupts and absolute power corrupts absolutely is so real in this case that it would be wholly inadvisable to allow this bill to be passed. But in the sad event that the bill is passed, then the next thing is to see when it is first used and then to challenge the use of the law as being unconstitutional, and that's something we will have to see down the road. But right now, what can be done, of course, is to lobby, to speak to write to your senators and other members of the Senate who are not representing the states, to persuade them that this is not a bill that ought to be passed, and it's not in the best interests of the country.
So it's our time to speak to our representatives.
Yes.
Yeah.
And, if you don't know who your representatives are, well, there is the internet. You can find out who they are, and you can try and contact them for meetings, get a hold of their emails, and send them your views about why you think that this is not a bill that ought to be passed.
With that, thank you very much, Andrew Khoo.